Thank you, Mr. Chairman, and thank you to the witnesses. I know it's been a long morning or now into the afternoon. Two proxy advisory firms, mostly through three index funds, are driving corporate governance across the entire economy. No one elected these firms, yet they wield incredible power. And to borrow a phrase from the progressives, they do it with other people's money. Mr. Copeland, if BlackRock and State Street are voting tens of billions in retirement assets, most of it from ordinary Americans who never opted into ESG activism, do you see that as a distortion of shareholder democracy?
Yes.
Would you agree Congress needs to explore ways to restore some voice to the ultimate beneficiaries, the retirees and workers, instead of leaving it all to intermediaries and advisors?
Yes.
Thank you. The First Amendment doesn't let the government force people to take political positions, but though Rule 14A through 8, activist shareholders are forcing companies into political speech as the price of being public. That's compelled speech by another name. Mr. Mueller, do you agree that many of these proposals are not about material business issues, but about forcing companies to take sides on divisive social debates?
Yes, we often see that.
Mr. Copeland, you raised First Amendment concerns in your testimony. Would you expand on how compelled corporate speech under 14A-8 mirrors the kinds of unconstitutional compelled speech that the courts have struck down?
Yes, I mean, effectively, these companies are being required to put on their proxy ballots political statements that are drafted from people like in the New York City Comptroller's office, right? And you know, that clearly runs afoul of a lot of compelled speech doctrine. I mean, there's some uncertainty about how this applies in the securities. What's unambiguous is that the way this is operating in practice, there's viewpoint discrimination. And I pointed that in my testimony where the National Center for Public Policy Research litigated this into the Fifth Circuit, and it was mooted, et cetera. But there was a situation where the SEC staff said you had to include on your proxy ballot a shareholder proposal talking about equal employment opportunity for sex orientation and gender identity. And the exact same language was used by a conservative group as a shareholder proposal saying viewpoint and ideology, and it said, no, you can exclude that, and a no action letter was granted. I mean, that's the sort of thing that should be troubling. It's a First Amendment issue.
That's right. Well, again, this gets back to the idea that it's more about compelling political speech versus getting back to the basics of, the actuarial component. Most retirees in Tennessee just want their pensions and 401k to be safe. They don't sign up to subsidize culture war battles, yet the proxies diverts resources away from shareholder value and onto politics. Ms. Keel, you gave the example of one shareholder forcing a company into expensive proxy fights over issues like DEI or gun policies. From a fiduciary duty standpoint, isn't that effectively transferring wealth from retirees to activists?
Yes, well, yeah, depends on whether it passes and they implement it.
Sure, absolutely. But the intent would be?
Yeah, so I think it's asking, it's a question of I think maybe a good example for this would be kind of climate targets, for example, right? Proposals are asking companies, a pizza company that I order my Friday night pizza from to impose Scope 3 climate targets. And so it's kind of hard to see the relevance to certain of these companies, and it ultimately kind of feels like an unsanctioned tax, really.
And I have more questions. I'm running out of time. I want to go back to this idea, Ms. Keel and Mr. Mueller. You both commented on the technically versus effectively with some of these proposals. So my colleague on the other side, technically was correct, but when you get back to the boardroom and how it's issued in the markets, please expand or put a fine point on technically versus effectively.
Sure. Companies don't want to be out there publicly opposing their shareholders. They want to be focusing on business and not being dragged into political debates. And so even oftentimes the vote is irrelevant. The shareholder has gotten the issue into the proxy statement, has forced the company to make a statement about it, and the shareholder doesn't really care what the vote is. They've achieved their purpose, and that's really kind of effective
Gentleman's time has expired.
Thank you, Mr. Chairman. I yield back.
The gentleman